Evening, everyone. Hope you're doing fine. You're all from work, you're sorted. And today, just want to share something about law of succession, specifically intestate succession. Intestate succession is whereby somebody dies, and in the process, he or she left no will behind. So, I want to take you through the steps that if something like this happens in your family, the steps that you will go along so that you can recover and share equally the estate of the deceased. The estate succession is whereby somebody dies and in the process he or she had left a will behind. This is so different from intestate succession. Intestate, there's a will. In intestate, there's no will. So I will start right away with the steps that you need to follow in intestate succession. First of all, you have to have the available requirements, all the available requirements of the deceased person for this process to start. Actually, this is the first step that you have to do. You need to have a burial permit. You need to have the ID card of the deceased person. All these have to be taken to the registrar of birth and death so that they can issue you with the death certificate of the deceased person. After you've gotten the two documents, you have to proceed either to the chief, or nowadays we have the DO and the deceased, in order so that they can certify that they know the deceased person, like they know the person existed, they know he or she stayed in that particular location, such things like that. After that has been done, the family have to partake something that we call the due process, and this I will explain in layman's language. The family have to get in place or try to know the property of the deceased person. If he had land, the family have to get the title deed. If the deceased had cars, the family have to get the logbooks, such things like they have to bring into place, write down the property of the deceased person, like get them all together in place. After that has been done, the fourth step that has to be done, they have to write the list of the dependents. And by saying the dependents, I don't mean that they are specific like family members. The dependents they can either be family members or not family members. It doesn't need to be necessary like the dependents are the brothers, spouses to the deceased. No, the dependents are not family members. It can either be family members or not family members. Yeah. After all that has been written down, they have to come up with the list, and this list shows that property is free from any encumbrances. If it's land, there is no charges on the land, like the property is free from all the encumbrances, from debts, something like that. If it's bank account, it's free from loans. If it's land, it has to be searched in the land registry to make sure that nobody had put in a charge on the land or something like that. Vehicle title deeds have to be searched in the NTSA, things like that. So the next step, after the list has been put down, we have to come now to the guarantees, and a minimum of 2 guarantees, it's enough. So this guarantee, they have to sign a bond. Yeah, and in this bond, they have to say that they have to make sure, they have to prove that everything about the land, about the deceased, that everything that has been said is true. And in many cases, they have to write that they have to pay some amount of money If it turns out that what has been written down is false, they have to pay some amount of money. Then after that, we have to get the administrators. Administrators are people who are in charge, people who will be in charge of the estate of the deceased. And here the estate, we mean the property that the deceased has left behind. So after all this process have been done, we have to go now to court. So the documents are filed to court. We can call them the petition documents, the petition of letters of administration. And by this, you have to file in the nearest court. If you stay in Kakamega, you have to file it in Kakamega law courts. There's no need of you filing in Nairobi High Court or Mombasa and you stay in Kakamega. You have to file in the nearby law courts. And then you get to realize that if the matter is of low value, you have to file it in magistrate court. Magistrate court, the maximum amount is 20 million. But if the matter is of high value, you have to file it in the high court. Then after all this, after the filing process has been done, you will be required to pay a small amount of duty to the court, and then the court will give you a document that will allow you to pay for the petition so that the petition can be placed on the newspaper, the Kenya Gazette. Yeah. So once the notice comes out in the Kenya Gazette, it has to remain for 30 days, 30 good days. And after the 30 good days are over, and there is no claim, there is no claim that has been made, we can then move on to the next step. And if somebody is opposing or objecting on what all the processes that we have gone through, then the objection have to be heard first before we proceed to the next step. The objection has to be heard first in court before we proceed to any stage. After all that has been done, and there was no objection, then the court will get a grant of representation certificate from the court, in this certificate it admits that people nominated, the administrators, the dependents of the deceased, or the people who had engaged in these proceedings are recognized by court. So after getting this grant of certificate, you have to wait for 6 months, and if there is special need, then the court, for example, by saying special need, I mean like the deceased had a child who is supposed to get school fees, the court can give permission before the 6 months elapse to get the funds for this specific purpose. You get? But if there's no need, there's no special permission that will be given by the court. You just have to wait for the 6 months. So after the 6 months are over, the administrator, the person in charge of the estates, will have to apply for the confirmation of the grant after the lapsing of the 6 months. After that, the family needs to sit down. The family, including the dependents and the administrators, they need to sit down now and agree on how they want the property of the deceased to be distributed. After they agree, they have to put it down. Actually, they have to put it down in form of sworn affidavit, and this will be signed by the administrator, and the dependent will have to sign on a consent document. They have to sign that they agree on the distribution and put everything down on something that we call schedule of distribution document. After all this has been done, and once the application is made, it is given a date by the court, and the people whose names are there have to appear physically in court with their IDs and say physically to the judge that everything is true. And in case a person is not in a country, there's no need for him or her to travel all around, because it's not economical to come all the way for something that is only for 5 minutes. So in such a scenario, the person who is in the other country can make a document that have to be stamped actually by the notary public for them to be given an exemption. So once the court has agreed with the family can go ahead and distribute the property. The court issued the family with the certificate of confirmation of grant. This, I don't know how I should put it, but I'll just give an example of the certificate of confirmation of grant. So in order to transfer anything of the deceased, let's give an example of a bank account. The deceased died, he had some money in maybe Standard Chartered Bank, and you want to transfer the account to be yours because the account has been distributed to your name. You have to issue the bank with the certificate of confirmation of grant before they transfer that account to your name. So you will find that this certificate will be asked in any office in order to transfer the property of the deceased. And the administrator who was nominated or appointed is the one who should be in charge. And you can find that if the family notice that some property have been omitted, like after all this process they found out that the deceased had some land, maybe he stayed in Kitale and he had land in Eldoret, the family can apply for the rectification of grant so that this property can be included. Just a reminder, something that you have to know. If this process is opposed by any member of the family or any other interested party, then the property ceases to operate. Everything stops. All this process that we have said, it all stops. And this will see that it will have given rise to a succession dispute. So all these parties, the different parties in disputes, they have to battle it in court until the court gives a finding or the courts give it a solution. This is where the tragic thing happens. So in my opinion, I may advise that it will be better to delay the filing of this process so that if there is fear of disagreement, it can be delayed so that by the time you file all the everything that we have discussed here, there will be no dispute. As I wind up, there are many laws that have interaction with law of succession. You have to know that law of succession does not operate on its own. It has interaction with other laws. Law of succession is not a vacuum. It's not on its own. It interacts with other laws. It operates in conjunction with other laws. Because you might find that some people may write a will that may be unlawful. And you may see that this may not be allowed. Will that is not right is not allowed by law, because according to law, even if you write a will, you get to know that there are dependents who are recognized by law. There are legal people who are entitled in that will. Yeah. That was just a short overview. In our next video, I'll share and explain to you about tested succession, whereby somebody dies and he or she had written a valid will. And we all know that will in Kenya, we have oral will and we have written will, but many instances we don't have oral will in Kenya. So thank you for watching. Remember to subscribe. Sorry, next time I'll be in office, yeah, as we discuss. Thank you very much.